Ms. Nadia Samdin.
Mr. Deputy Speaker, sir, COVID-19 has accelerated the digitalization of processes for Singaporeans. Whether it's working from home, scanning QR codes, or managing digital wallets, many of us have become more comfortable with the use of remote technologies and virtual conferencing. I'm glad that we are now making amendments that will hopefully see the same benefits of digitalization brought to the Sharia Court or SYC. I would like to ask for some clarifications, mainly relating to the digitalization and stakeholder preparedness for new processes to ensure the quality of proceedings do not erode in the transition online, and consideration for areas and scenarios in which digital processes may not for the time being be sufficient. The insertion of Section 45A provides that the SYC or Appeal Board may conduct hearings through electronic means of communication. There are challenges and potential points of amelioration in the transition to digital proceedings from the perspectives of court, counsel, and witnesses. Safeguards need to be put in place to protect, among other things, the propriety, solemnity, integrity, and orderliness of proceedings. It is important to ensure that each party can express their case independently, fairly, with all relevant details. The complexity of this transition must be tackled head-on. For the SYC users and officers who may not find the digitalized processes intuitive, or those who want to use them but face difficulties, what training, resources, and support will be available for individuals who need help, in particular SYC staff or litigants in person? How long will the transition take, and how will ongoing cases during this transition be impacted? Currently, the choice of setting up a dedicated venue to provide a conducive setting for online hearings is left up to the discretion of counsel. Not everyone can afford representation, and even when they can, there may be other prohibitive factors that come into play. Will the Minister consider establishing a centralized, dedicated venue to facilitate this? There are also lessons which we can learn from incidents overseas. An online court hearing held in the US in March 2021 was halted when a prosecutor realized that the victim and her abuser were in the same room in her house. The abuser intended to intimidate his victim to coerce her into adjusting her testimony by being in a position where he could threaten her safety. He did this while pretending on screen that they were in two separate locations. It was fortunate in this case that the prosecutor caught on. But unlike a physical court setting, where there are significant safeguards against intimidation, the possibility of a similar scenario in the example earlier is more likely online. What checks would be in place to prevent such actions from happening? Many of us would have also experienced frustrating technology failures at some point, for example, due to an unstable internet connection or an issue with the device. It would be important for parties to virtual court proceedings, to be permitted to change to an alternative device if a party encounters video malfunction in the midst of a remote hearing. However, in the event there is no alternative device, would parties be permitted to defer the proceedings? I also understand that in such an event, with all parties' unanimous consent, the SYC may proceed with the remainder of the hearing through live audio link only, without an accompanying live video stream. Without an actual video feed for corroboration, I would like to ask what safeguards will the SYC put in place to ensure that proceedings conducted by electronic means are conducted in a way that's fair to all parties. As we move forward with these changes, it will be useful for the public to also understand factors that are considered by the SYC when deciding under what circumstances will a matter be decided without hearing oral arguments, as permitted with the insertion of Section 35B. For such matters, the judge will be making decisions based on affidavits and submissions only. In such cases, could the Minister share some examples of proceedings where oral arguments will not be necessary? I ask this in hopes of getting clarity that there will be little risk for those who are not equipped to provide an affidavit with enough relevant context or details, in particular any litigants in persons, and also in hopes of preventing further disputes. Tuan Timbalan Speaker, pindaan rang undang-undang ini akan membawa kesan positif kepada proses pembicaraan, lebih lagi sekiranya kita menghadapi situasi rumit seperti pandemik yang tidak membenarkan pihak tertentu untuk bertemu secara fizikal. Namun, di samping kita berusaha untuk melaksanakan prosiding digital, amat penting bagi kita untuk memastikan setiap pihak dapat memberikan kenyataan dan mendapatkan perwakilan secara adil, penuh dan bebas dari ancaman atau ugutan. Dalam ucapan saya telah membentangkan 3 fokus utama. Salah satunya ialah bagaimana Mahkamah Syariah dapat mempertimbangkan beberapa situasi di mana proses pembicaraan mungkin tidak sesuai atau belum lagi sesuai untuk diadakan melalui talian. Pokoknya, kita harus prihatin bahawa masih ada sesetengah masyarakat kita yang mungkin belum bersedia untuk peralihan ini dan usaha pendigitalan kita haruslah memudahkan proses pembicaraan dari perspektif pihak-pihak tertentu tanpa menjejas keselamatan, perlindungan dan hak setiap pihak untuk mendapatkan akses saksama kepada keadilan. Saya harap pindaan ini tidak akan menambahkan tekanan atau kesusahan bagi pihak-pihak tertentu dan saya berharap juga persiapan, sokongan dan sumber yang mencukupi akan disediakan bagi setiap pihak, termasuk juga pegawai-pegawai mahkamah dalam peralihan ini. Mr. Speaker, sir, Mr. Deputy Speaker, sir, a secondary area of clarification that I have is with regard to the proposed Section 43C, which has also been raised in a previous setting as mentioned earlier. I am heartened that support for children is becoming more explicit and expanded. This is important, as even though it was mentioned then that the bulk of responsibility should fall on the parents, during these difficult times especially, not all parents may be sufficiently equipped to also play the roles of counselors, psychiatrists, and other roles for a child's care that may require a professional to better protect their well-being. These complexities raise questions on who should be making the decisions for the programs and how they are arriving at them. I would like to clarify what would be guiding the decision-making process the courts will be using to reach a specific program recommendation, and what are perhaps some of the factors which will be considered in order to accomplish this. Furthermore, even though parents want the best for their children, grief and other stresses might make it difficult for them to comply with the order. How will we make sure that there is also appropriate support and resources for parents? And if parents prove that they are unable to comply with the order, what other steps can be taken? In the context of the amendments at hand, how will the programs be tailor-made for our community, and how can support be better coordinated in the best interest of the child? While so much has been made possible and more convenient with digitalization and broader access to support programs, it is important that the interests and quality of justice remains the overriding priority in this case. Notwithstanding my clarifications, I support the bill.